the idea that a judge would decide how much money a person would get based on where we are in the cycle to me sounds insane.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant and soon-to-be licensed paralegal.
Welcome back to Water Cooler Justice. We have a very special episode in store for you today. If you've been enjoying Water Cooler Justice, take a moment to follow, leave a rating, or send your favorite episode to a friend. Support is always appreciated. Today, we're joined by a very special guest, Rich Diaz. Sarah and I are excited to be speaking with Rich today. We know Rich is one of the three amigos and co-host of the Loonie Hour podcast, a podcast dedicated to breaking down Canadian and global economics. Rich is a global macro strategist with over 15 years of experience working for institutions in both Canada and the UK. Currently, he's based in Montreal with IceCap Asset Management as a global strategist. Rich has dedicated himself to translating complex macroeconomic data into plain language, giving everyday Canadians insight into the economic forces shaping their lives. We're thrilled to have him. Welcome, Rich Diaz.
Welcome.
Applause. Yeah.
Thank you
So
for the
excited.
extremely warm welcome. I appreciate it.
Yes, we're so excited. How are you?
I'm a little hungover.
That seems right on a Friday morning, actually.
I like, so one of my very, very dear friends, his son is my godson. And he and I, we bought a bunch of tickets to the Montreal Canadiens for the season. We didn't buy season tickets. We're not millionaires, but and last night was our last pair of tickets, and we got to see Montreal play against Tampa Bay, which is a very, very big deal. And we got to see Cole Caulfield score his 50th goal, which was a huge deal. And we had many, many beers.
Did the place go wild? It must have been crazy.
Honestly, it was one of the most intense and exciting and positive sporting events I've ever been in. It was amazing. The crowd was absolutely electric. Everybody, obviously, that was there knew what was going on. It was a really important game for the standings, and on and on and on. And we were just super pumped, and we just had a fantastic time, and it was so cool.
So Cole Caulfield is awesome to watch.
Yeah. So
I love the highlights.
Yeah.
But we had a guy here in Toronto who managed to put 60 in.
Oh, Jesus. Yeah, he's amazing.
Yeah, he had a
69.
season too. Yeah, he had a season. But what's it like? What's the temperature like in Montreal with the team doing really well? Because I can tell you here, it's rough times in Toronto. We're having our best year.
We're ahead of schedule. We're rebuilding. Everyone is like cautiously optimistic. We've got all the pieces, and it's just nuts. It's just totally unhinged.
That's a great way. That's a great way to look at it. Ahead of schedule. I remember when the Leafs, started adding their pieces and we started to put the thing together, and we might have planned the parade a little too soon, but it was our last 9 years were a fantastic run until this season. We'll have to see what they can do. But I'm watching Montreal with great enthusiasm. That's definitely the team I'll be cheering for. Although Edmonton's a close second, but Montreal.
I hear you. I mean, it was just fun because I think in a world that's just like totally crazy, and we're going to talk about Canada's economy. It's not doing so hot. It was just nice to have good, clean fun. And then we had too many beers, but in general, it was like an incredible amount of positivity directed towards young men who've worked really, really hard to get to where they are and have delivered and are. And it was just awesome. It was awesome. So anyway, there we go. But that's not what we're here to talk about. What are we here to talk about?
Well, it's a team game, right? So their teamwork, it looks really good.
Yeah,
so
it's great.
Speaking of teams, Sarah, why don't you set the stage for our listeners?
Of course. So our focus today centers on one of the famous Bardal factors, which courts use to determine the reasonable notice period for a wrongfully dismissed employee, specifically the availability of alternative work. Now, the Bardal factors shape the foundation of the wrongful dismissal damages in Ontario. They are age, length of service, character of employment, and of course, availability of alternative employment. When a court determines reasonable notice period, let's say 12 months, they're implicitly saying that this is how long it should take a specific person to find a comparable new job if they diligently search for work. Chris, can you tell us a little bit more about each Bardal factor specifically?
Yeah, I mean, I've got a few thoughts. I'll just run through them quickly to fill out the table a bit, and then we'll really focus in on that availability. Age at the time of termination is a Bardal factor. There's a view that older employees are entitled to greater notice, premised on the idea that these workers are in their peak income years, and that the loss of employment's got a greater impact. I don't know that I agree with that. I certainly don't think that younger employees are having an easier time in the GTA job market currently. I do understand the court's concern around involuntary retirement from working life, though. Can a 62 or a 63 or 64-year-old employee find comparable alternative employment, meaning employment that's going to pay them what they were earning? Will employers invest training costs in a new hire that may retire in a few years' time? Length of service is another area that people often misinterpret. The expression 1 week per year of service is a reference to the statutory notice under the ESA in Ontario. In fact, ESA notice, though, can be as much as 34 weeks and can exceed common law notice in circumstances where there is no regular work week. And there's a heavy weighting based on performance based compensation in the ESA formula. So a lot of employers actually fall into a trap there. The expression 1 month per year of service is a reference to common law notice, which is often wrong as well. Short service employees routinely get 3 months, 6 months notice, and executives often receive notice in the range of 3 months per year of service or more. I will say that length of service is probably the place where I like to start the analysis. It gives me a chance to tell the story of the employment relationship to the court. If the employment was short lived, why? Was there a workplace incident or complaint? Did the employee take a leave of absence? If the relationship is longer, then I can lean into the specialization of the employee's skills to the needs of that particular employer. Character of employment, this one's really of diminished importance in Ontario. There's a Court of Appeal decision on that. Courts no longer really hold that the ratio of job openings to qualified applicants is tighter for executive employees than it may be for introductory hires or general laborers. And so I think that's one where I think I would pull back increasingly in my analysis. And then the last one, and this is the one that I think is the most interesting, is this idea of availability of alternative work. It flies under the radar because it seems difficult to evidence, and it likely requires contemporaneous evidence of job opportunities sent to the plaintiff during their search, which is counterintuitive for employers, right? Like, do I really have to do the employee's job search for them? At trial, it's often based on anecdotal evidence, perhaps the plaintiff's own job search efforts or media commentary about the state of the local job market. The idea is that if there is less work available, then there should be a longer notice period given to the employee. If there is more work, then the notice period should be shorter. What we're going to explore today is how we can move beyond the anecdotal and introduce robust economic data. And I think that's where, Rich, you come in, right? One of the things we're really struggling with is how do I show a court what the employment circumstances or the job market was for my particular employee at the time they were doing their search, other than job postings, that I pull off Indeed. Thoughts?
Holy moly. Is it I mean, the first thought that comes to mind is why are courts analyzing any of these kind of market forces? Why are they asking and telling people what to do and what businesses should do and et cetera, et cetera? That's the first thing that comes to mind. It's not clear to me that all jobs are fungible. It's not clear to me that experience is fungible. It's not clear to me that age is fungible. In general, unemployment rates for older people are much lower than they are for younger people, but participation rates are also lower. There's also a cyclicality to it that's really, really key, a huge component. So right now, Canada is in a recession, has been, in my view. I know that that's not the Bank of Canada's view, but I think Canada's been in a recession for 2 years or 3 years, basically, as a function of our productivity
Yeah, well, that's
emergency.
been our experience in our practice too, right? Like we're very,
So,
very busy.
Busy.
like, for a judge to say, you need to give this person this much money because right now we are at this point in the cycle. How is the judge, all of a sudden we are like deputizing the judge to understand where we are in the cycle, what's next? All of that stuff to me sounds extremely tricky.
Yeah.
Um, I'm not
That's
sure
why
I
we
answered
brought
your
you here.
question at all,
Yeah,
but,
lawyer. Well, so we've been wrestling with it for a long time, but it sounds to me like right off the hop, one of the things you're really saying is if unemployment is high,
yeah.
does that necessarily mean that courts should be awarding greater notice? Does that make sense from an economist perspective?
Uh, I don't think so. I think there should just be a standard number that's not related to the cycle. I think as soon as you start tying people's notice periods to where we are in the cycle, I think that adds a level of complexity and complication that I'm not sure any of these lawyers signed up for. Does that make sense?
It absolutely does, because we talk all the time in law about how we're looking for certainty from the courts, right? How am I supposed to advise my clients on what their notice period should be if it's dependent on, for example, what you say, that where we are in the cycle? I'm not an economist, right? Where do I get that information from in order to punch it into a formula or to put it into my thoughts around what the reasonable notice period should be? It's a real problem, right? And the test that we've created has this evidentiary hurdle. And the thing that's interesting about law, or one of the things that I find interesting about this area of law, is that the party who asserts is the party that has to prove. So if you're saying that there's more jobs available in this particular field, it's incumbent on you to demonstrate that with evidence. If you're saying there's fewer jobs, it's incumbent on you to demonstrate that with evidence. And again, one of the reasons we were sort of super excited to have you on the show was, is there a place where someone can look for regional unemployment numbers? Is there a place where unemployment is broken down by industry, or perhaps by education, or perhaps is that information actually available somewhere, or is it just, you almost would need an expert witness to come in and help you decipher that?
No. So I mean, in the US, for example, they have unemployment and vacancy rates by state and sector. Canada doesn't do as well. If I might be mistaken, but you don't have vacancy rates by sector per, let's say, province, for example. And then
Right.
if you do, those sectors are extremely broad. There might be 11 or 12, whereas like in your world there might be 30 or 40 different types of job postings or whatever. So like
Right.
education would be like one silo, or professional services and technology would be another, like manufacturing. My goodness, there's a million different types of manufacturing, everybody from who runs the operations of that manufacturing firm to the guy who's sweeping the shavings of a machine or whatever. That's very, very tricky. I mean, the other thing that we actually, what just occurred to me when you were talking about it, is the fact that this is actually pro-cyclical. So, like, when things are the worst, let's say unemployment is very, very low, meaning that there's tons of jobs available, meaning that your notice period should, in theory, according to the way that you described it, be very short, is actually the time where it's likely going to, you know what I mean? It's that wave is mean reverting. So at a time where unemployment is extremely low, you might offer someone extremely short notice, expecting them to go out and be able to get a job quickly. But at that point, you almost certainly have a upshoot, like you have, like, going forward, you might have unemployment rise. Similarly, when unemployment is extremely, extremely high, you might say, well, the job market is really bad. We're going to give you tons of notice, tons of compensation for this, given that the job market is so bad. That's often the peak
Right.
in the unemployment rate, and you're likely going forward, it's almost certain that unemployment will fall. Does that
Right.
make sense? So you're
It absolutely makes sense, because I have clients who come in and say, I've looked online or I've done a search and I think my notice period should be very, very long. And I have to say to them, well, actually, the factors are shifting and the notice periods are coming down. Or conversely, they come in and they think their notice period should be some shorter amount of time. And I say to them, actually, the factors are shifting and notice periods are longer than that currently. So, and the other problem we have is our court system, as you may know, is not fast. So
Well,
it can
that was
often
that
take
was my question. Why are we
it
doing
can
this in
often
the
take
courts?
it can often take 2 or 3 years to, have a trial where you're gonna have a final adjudication, and the problem is the economy at the time of trial is often extremely different than the economy at the time of
Yeah,
termination.
of course.
And how do you put the judge into the mindset, or how do you take the judge back in time and say, "Hey, this is what it was like during the period of time that my client was searching for work." Right? So it's funny that you say that. I mean, these are the exact this is the thing that underpins the experience that we actually have. So I find it fascinating. But what I'm really hearing is, and I wanted to say one other thing too. The categories of work that you described, those actually, a lot of those words were sort of buzzwords for character of employment. There was a certain character of employment that was professional. There was a certain character of employment that was manufacturing, right? And that's something that courts have been pulling back from, right? Because they've realized that, this idea that there are fewer executive jobs, but more laborer jobs doesn't translate into greater availability of work because the ratio of candidates looking for those positions may be the same or quite similar. Like there may only be
Yeah,
100
vacancy
executive
rates.
jobs, but there may only be 10 people looking, right? There may be 1,000 labor jobs, but are there only 100 people looking? Is it all the same, right?
Can I ask a question? So
Yeah, sure.
when I worked in London, we just
We're
had
flipping the script here. Oh my goodness.
no, but we had like our notice periods like in our contract. So they would give you 3 months
Mm,
gardening leave.
yes.
So my
So,
kind of
yep.
question is like, why are courts bothering with this at all? Like,
Wow. So here you go. Okay. So
Now
you
you're going to
put
get
your,
into
you,
it.
no,
yeah,
but
you put,
genuinely,
why am
like,
I getting red in
Yeah,
the
yeah.
face, right?
no, but genuinely, like when you sign an employment contract, say, I'm going to go work for IceCap Asset Management. We are a portfolio manager. We manage money for families all across Canada and the rest of the world. Keith, in my employment contract, we
Uh,
have 4 weeks of vacation, I have
yeah.
insurance, blah, 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 blah. And it says you have to give people notice. So in the UK, it's explicit. You have to give 2 months notice, 3 months. So why are courts adjudicating
I'm,
this on this at
I'm
all?
going to, I'm going to take you on the journey, man. So there was a case called Mactinger v. Hodge, where a relatively prominent lawyer managed to convince the court that a properly drafted contract could lead to the termination of the employee for only the statutory minimums that an employer needs to pay under, for example, the Employment Standards Act or the Canada Labor
I
Code.
don't know what any of that
And
means.
okay, so great. So let's back up. The Employment Standards Act, when you terminate somebody, it has a notice provision. It's 1 week per year of service up to a
Okay.
maximum of 8 weeks, right? A common law notice typically is around 1 month per year of service or more. So the idea was in Mactinger, the idea was that you could write a contract that took away that common law notice and just limited you to the statutory amounts, the 1 week. And the statutory amount has to be paid. You can't contract out of these acts. They're sort of minimums. They're protections for workers everywhere, right? The problem that arose was that when the companies went to draft the termination provisions limiting to the minimum amount under the act, they couldn't resist the temptation to take just a little bit more. And so the provisions, when they're interpreted, often provide for less than the Employment Standards Act minimums, or they provide for less than the Canada Labor Code minimums. And the result is that those termination provisions have been deemed by courts to be void. And in the absence of a valid and enforceable termination provision, you're entitled to common law notice. You're back up to this 1 month or more per year of service. Our whole business turns on taking those employment agreements, tearing them apart, and returning the client to their common law entitlement.
So what's the
And
point of the employment agreement?
well, there are a couple of points. One, you can draft a valid and enforceable agreement. There's at least one court in Ontario that agrees. It's a case called Birch v. Data Stealth. So that's the first thing. If done properly, you've achieved the goal for the corporation. You've achieved certainty between the parties. So it can be done. It's just rarely done properly. It's very, very difficult to do. And conceptually, really, increasingly, I'm coming around to the idea that it may not be possible to do. That in fact, the nature of the statute, the way the statutes, there are a lot of statutes, not just the Employment Standards Act. Occupational Health and Safety Act provides protections to employees. The Human Rights Code provides protections to employees. And And for example, under the Employment Standards Act, the Occupational Health and Safety Act, and under the Human Rights Code, there are times when you simply cannot terminate at all. And so a provision which purports to allow the employer to terminate on minimal notice, which traipses or unfortunately crosses into these protected periods, that fails too. So we just had an appeal case in Ontario.
Sorry,
Yeah.
I'm not understanding. So you cannot fire somebody? Can't you just pay them out?
Well, you can terminate somebody, you just have to pay them notice. Yeah, you either give advance working notice, hey, it's not working out, in a couple of months' time,
Here's
we're going to
3
let you
months
go.
gardening leave, off you go.
Or alternatively, it's not working out, your employment's going to end today, and we're going to pay you in lieu of that notice. You can do that. The fights, Rich, are not about whether or not notice is required. The fights are about how much notice is required and how much, what the payment would actually be. So the other interesting thing that happens in employment law is people fight about whether you get your bonus during gardening leave or whether your RSUs vest during your gardening leave.
Yeah, that totally makes sense to me. I just in my head, the idea that a judge would decide how much money a person would get based on where we are in the cycle to me sounds insane. The judge
Yeah.
Yeah, it's a little
So
insane.
we wrestle with that. That's what this whole podcast is about. I'm so glad you've come on.
right? Like
You put
I'm
your
not trying to
finger
be
right
funny.
on
I'm
it,
just
right?
like the
Yeah.
judge is
No, I
now an
know.
economist or like a global strategist. Now the judge has to look at the unemployment rate and then look at the vacancy rates
Well, the
for
thing is,
jobs.
Ontario's very employee friendly. So they're looking at it more so from the employee's lens, right? And so the idea behind those Bardal factors, things like your age, your length of service, availability of alternative employment, is to make the employee whole. So if your employment contract is invalid and let's say the employer has wrongfully terminated you, they're just trying to make the employee whole back to the original position. So
I have a
you're
dumb
right, it is very employee friendly.
I have a dumb question though.
Yeah.
Why would you sign something that wasn't valid?
Well, that's a
So
good question. Yeah.
courts
And if you
wrestle
do
with that.
sign something that is not valid, like, isn't it tough shit for you basically? Like you signed a contract.
Well,
You're of sound mind, hopefully, not
Mhm.
hungover after the hockey game.
Yeah.
You read the contract. The contract said XYZ. You, as an adult and
Mhm.
a person, you signed it. Shouldn't that be the end of it?
Well,
Mhm.
so you're not wrong, but what courts have repeatedly sort of leaned into, or the two of the themes that courts will lean into when presented with that argument, is one, there's an unequal bargaining power, right? At the
But
time
why
that
is that relevant though?
well,
You signed
courts,
the you signed
the
on the
courts
dotted
do
line.
think it's relevant, but that's not really the legal hinge on which this all turns. The legal hinge that this all turns on is the idea that the Employment Standards Act minimums, or the Canada Labour Code minimums, or the protections under the OHSA or under the Human Rights Code, these are minimums, and you cannot contract out of them. And so the real reason the contracts fail is that the employer has drafted an agreement that goes too far.
Right.
It
But if
right?
you're a lawyer and you draw up a contract that's above those minimums across the
Mhm.
board for all the different things, and then I, as an adult, sign it, what
Yes.
legal stand? Like, I don't understand. Like, you're gonna
That's
then
correct.
sue?
No, but that's you. So you put your finger right on it. So we have a guest on the show.
If I was the
all the
judge, I'd be
time.
like, can you tie your shoes? Yes. Why did you sign this thing? Do you
Right.
meet the minimum threshold? I
Well,
just
we have
toss it.
I'll jump in
I
if
want to
I
take this one.
can.
I want.
Oh,
Okay, you go,
'cause
Sarah. You take it. We want to. Oh yeah, we both want to talk.
Well,
All right.
I
I'm
know,
not a
'cause
lawyer, so I don't understand.
Yeah.
But
Employment law essentially goes back to contract law. And so when you're drafting contracts, you have to make sure, first of all, the parties that are signing it are not under duress. They understand the provisions that are in the contract. As an employee, you don't have much bargaining power, right? Because the company is drafting the employment agreement. They have a whole host of lawyers behind them.
if
They
you're not a
don't
slave, no one's
understand.
forcing you.
Of course. Yeah.
Well,
I agree
but
with you. I'm just
I'll-
explaining this is
No,
how
but
the
what I'm
contract
trying
law.
to understand why, if like again, as a layman, if you signed a contract that
Mhm.
says you're going to do the following things such that it meets all of your minimums,
right.
how do you then turn around and go, "Oh, well, I didn't have the right bargaining power at the time."
You know what, Rich? You put your
Yeah.
finger right on it. We have a guest who comes on
Mhm.
the show all the time. His name's Barry Fisher. I love him dearly. He's
It's
an early
hilarious.
mentor for
Yeah.
me, super funny guy. And he's been doing this, like I've been doing this for 20 years. But when I was doing this guy was long in the tooth. He's seen every case. And what he always says is stop trying to make the floor the ceiling, in the sense that stop trying to make the ESA minimums the contractual period. Give the ESA minimums plus some small amount so that you're clearly over the floor. You're
Why?
clearly over the minimum standards. Well, that way a court can't turn around and say that you're somehow below the standard,
But
right?
I'm sorry, the word minimum means above this, you're okay.
Right. But the problem is that the provisions which are drafted often go below the floor.
Okay,
They
well
go
then
below
that's
the
but
minimum. It's
I'm just trying
incredibly
to understand
challenging.
how you could go to a judge and be like, "We've reached the minimum on all these different provisions, and I'm
Yeah.
still not happy because."
So you're sort of espousing, or you're really presenting very clearly the common employer argument when they're seeking to enforce the provision. And in Ontario, for example, we just had a Court of Appeal decision on a phrase called "at any time." And so if your termination section says we can terminate you at any time by giving you all of the minimums under the Employment Standards Act, that will satisfy our obligation to you on termination. We have in Ontario several courts have gone both ways. Some have said the phrase "at any time" is less than the ESA requires, because you cannot terminate under the ESA during a protected leave, like a leave of absence for a medical reason, or for elder care, or for child care, right? And we have another group of courts that have heard the same phrase, heard the same argument, and they've come to the conclusion that there's nothing wrong with the phrase "at any time," but if you say "at any time because we want to," or "any time in our sole discretion," then that crosses the line, because it clearly means you intend or could intend to terminate during a protected leave. And so we have, so
But
that's
what if
gone
you
to
wanna
the,
fire somebody because 'cause they're
you have to
not
give them
useful?
so the truth is you have to give them notice.
Yeah, yeah, fine, 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 I get it, but
And so this is why we come back to availability of alternative employment. Once you've agreed that you have to give them more than just a statutory or a formulaic notice, we get into this analysis: character of employment, length of service, age, availability of alternative employment. And we struggle. We've pulled character of employment back out of the analysis. I have questions about age, because I think younger employees are having a heck of a time right now.
yeah, our government
Um,
completely screwed over an entire
yeah.
generation of people.
Well, so that's a theme of the Loonie Hour podcast, which frankly, it
It's
resonates for
true.
me. Right.
Mhm.
It resonates. And I certainly can see it, when I think about my parents' experience, my own experience, and I think about the experience that I have children who are sort of in their teen years. I think about the experience that they're going to have moving into the workforce. And as we talk about on our podcast, sometimes employment law gives you we're a little bit of a canary in the coal mine, in the sense that things change for us just slightly out of cycle with how things are reported. We can see mass terminations. So a lot of times when there's a restructure, executives are the first to be let go, then the next round of managers, and then down to the next round. So we can see sometimes, when there's a few executives being let go from the same employer, or across the same industry, we can see what's happening and we know what's coming next, right? But to come back, I've lost my train of thought, but to come back to it, I think that there is something to the idea that is a generational issue, right? And I see it in employment for
The
sure.
the data is very
Um,
clear on this.
right. Well, so I can see it in employment. I can see it across. I can see where my older employees are. I can see where employees of an age with me are. I can see where I can see where young people are, and not everyone's experience is the same, right? Like some people are more successful than others, but generally, in a practice where I'm doing hundreds of claims a year, I have enough of a sense of what's going on, at least in
Mm.
Toronto, in my little area. I have a good sense of what's going on, and you can see where incomes have stayed flat for 20 years. You can see where incomes have gone up suddenly. You can see, for example, post COVID, you could see you don't like your job, change your job, get a $30,000 raise during the so-called labor
Tight
shortage,
labor market, yeah.
right? And then you can see once the labor shortage is resolved, you can see in the terminations what's happening, right? So there's all kinds of interesting, we can sort of see a little bit about a little of what you guys talk about in your
Absolutely, that
podcast all
totally
the
makes
time.
sense.
Yeah, but that's why I wanted to have you on.
Can I ask another dumb question?
Yeah, no,
So
no dumb questions. They're only questions.
so let's say like person A gets fired, and then the judge basically looks at the unemployment rate and the vacancy rate and the average salary for that person in that career, and then decides like that's your compensation.
They decide on a period of notice, 3 months, 6 months, 9 months, and then there's a second set of arguments about what compensation will get paid during that period. So it's a two-tiered quantum fight. The first is how much notice, how long should the notice period be? And the second fight is about how much should be paid during that period. And so there are interesting cases. So one interesting case or one interesting theme that we've been talking about a lot on our podcast is RSU compensation.
What does that mean?
R-
Sorry, RSU.
RSU is restricted stock units. And so they're sometimes called contingent compensation or at-risk compensation. And there are even employers where the employee can select. They literally have like a little bar on a computer screen. They can tip the bar towards salary so they can get greater salary, or they can tip the bar the other way and get lower salary and more RSUs. And a lot of employees will select the RSUs because if they go up in value, it creates sort of
Your
creates
incentive are aligned.
a compounding effect, right? The problem is on termination, those RSUs are forfeited.
Was that in
And
the contract?
it is in the contract, and that is often enforced, right?
Okay.
So there are some really fascinating stuff going on in employment law. But, so to your point, if you wanted, I'm not going to tell the employers how, well, maybe I will. If you wanted to draft a contract and you wanted to pay less on termination, using a compensation scheme which has been enforced by courts that causes a forfeiture or a loss of income during the period makes good sense, right? That's one way to approach the problem, right? But yeah, so this Court of Appeal decision. So again, Barry Fisher, friend of the show, went up to the Court of Appeal and listened to the arguments. And the decision isn't out yet, but one of his summaries was that there were something like 47 different statutes or statutory sections that would be breached by the words "at any time" in an employment agreement. And so I thought that was fascinating because it really begins to, I think, as we analyze and we get more structured analysis, we're getting better analysis. Like lawyers, like any profession, we're getting better over time. I think computers and AI are helping us synthesize arguments and boil down arguments to their core. And I think we are starting to struggle with the very thing that you, as an economist, looking at this, you put your finger right on it, which is this doesn't make sense. Right?
I have another question.
Yeah, please.
One of the
This is the best.
one of the really major problems that Canada has is productivity. It's dog shit, basically. It's very, very poor in Canada.
You can say dog shit on our podcast. It's okay.
And the reason it's bad is because companies are loath to invest here. And part of the reason they're loath to invest here is because of things like the carbon tax, which is completely insane. High taxes relative to other countries when you're, but also because of regulations around labor and stuff. Do you feel like that this is an issue do you see foreign investment go, well, we were going to hire 3,000 people to work in a factory, but it's extremely onerous to fire them if we change our mind or it doesn't work or blah, 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 blah.
I don't know that our regulation is what drives people out. I mean, it's either lucrative to be in business in Canada or it isn't.
Well, you're taking risk. That's the point. You're just
or you're making what you're doing is you're making the threshold for profitability higher. Right.
So
but what I've been seeing since President Trump was elected is that a lot of executive and a lot of small head offices and a lot of regional offices and a lot of sales, I see a lot of that going back south of the border. I see a lot of, there used to be separate territories, Canada and the US. And now there's one territory, North America. And all of the employees are resident in the United States. So certainly I've seen a lot of that. I don't know that the American employers are particularly aware of our common law entitlements on termination. And so that's actually been, leaving aside the loss of employment, they've had to pay some fairly large notice periods because their contracts are drafted with American law in mind.
Oh, interesting.
Right. So,
And what,
like,
the
there's been
Canadian
some
law supersedes that contract?
Yeah, it's jurisdictional,
Okay.
right?
Yeah,
So
okay. I don't- sorry,
where
I don't-
you
again, I don't know
live,
any.
where you live is where you work, and so Ontario courts are happy to take jurisdiction. There are cases where you can have an Ontario court enforce American law. There are cases where you can
With bonds and stuff and like financial instruments?
well, no, just like for employment purposes.
Oh, excuse me.
only.
Okay, sorry.
Just for wages, right? Because employment is a provincially regulated
Do you
matter.
see? So, for example, I live in Quebec, and it was a pain for my boss Keith.
Yeah.
And he
Quebec is
basically,
special.
well, he basically didn't like, and he would never admit this. I'm gonna get him in trouble now, but he was like, "Are you sure you want to live in Quebec? It would be great if you didn't." You know what I mean?
Yeah. Well, so Quebec is a different.
My
Quebec,
point was more about, like, do you see companies decide to set up their offices in certain jurisdictions based on how annoying the law is?
Not yet. I mean, could that happen? Sure, but like if that was going to happen, there are a host of reasons why everybody would be in Alberta already. Like just sales tax plus income tax.
So it's
I
not
also
specifically the employment law.
I don't know that
Right. So, but
employment law is like big enough of an
Okay.
issue compared to
Okay.
other things like the carbon tax and bureaucratic red tape. Like Chris can speak to this because I haven't been in the industry long enough, but I'm not even sure a large proportion of employees actually go and litigate wrongful dismissal. Like
Okay.
you said, most people
Fair
are,
enough.
oh, I'm an adult. I signed a contract. I will just take whatever the company gives me. So I don't know how big of an issue it actually is with respect to companies considering that as a factor when they're investing in a particular province.
Yeah, fair enough.
Sarah
You're
makes-
right. You're right.
Sarah
It's
makes
not.
a
It's not
really
that big a
good
deal.
point.
I was just trying to understand more, like, holistically. I was just looking at the regulations around manufacturing in Canada, and like Canada's manufacturing sector is hemorrhaging jobs. And this, by the way, was before Donald Trump and his U.S. protectionist bullshit. Part of the reason is because we have a massively growing number of regulations, and it is not easy, frankly, or desirable to open up a business here. And so when I hear things like what you've described, which is like, it makes me wonder about what the future of our country is if people who sign contracts still are able to litigate and win, and
Well, so again, that's a theme on our podcast all the time. Why isn't this just the matter of statutory regulation?
Yeah.
Why hasn't the government stepped in and just removed this? Why are the courts burdened with it? And we've had lots of conversations about, there are lots of employment lawyers. There must be thousands of them. Although in Toronto, I'd say there's like, maybe somewhere between 300 and
At least
400,
one.
like real ones. No, but like, people who are really engaged with the particular practice area, right? But one of the things that, we've often joked about is, the day the government regulates, notice, we're all out of a job.
Yeah, I'm weary of government regulation, so I'm not sure if as you
Well,
said
the
that
government
to
already
me.
regulates. The government's
Like,
right?
I'm just trying to understand. Like, it's kind of a fascinating world that you've sort of shed light on. I just had no idea that this was even a thing. Again, my only experience to things like notice and gardening leave is like when I worked and lived in London. I mean, that's what it was called, gardening leave. You would just get paid your 3 months, and that was it. You'd have to.
Common law. Our common law is rooted in the same law that you're describing, and sometimes it's called garden leave here, but mostly we call it notice or pay in lieu of notice.
Yeah.
I'm sorry to your employer if I have flagged for your attention something that you can look at in your contract. But the reality is, I think Sarah said it best, right? So many employees fail to pursue this entitlement. And a lot of employees, until very recently, wouldn't have had access to courts because contingency fees, where the fee for the lawyer is a percentage of the recovery, those weren't permissible in Ontario. So in order to seek justice, you would have to, as an unemployed
Really? Even
person-
for like ambulance chasers and stuff?
Right.
No win, no
until
fee or whatever? Like,
very, very recently.
really?
And so as an unemployed person, when I first started, I had to convince each of my employee clients that it was in their interest, notwithstanding that they were only getting employment insurance benefits or some small payment under the ESA, to take some money out of their pockets and put it into my trust account to pursue a greater entitlement. Right.
Interesting.
And, so I built the practice. I built the practice that I have by winning, right? By getting results. Now the contingency fees are legal. I can see already there's a lot of marketing. There are a lot of firms with money that are moving into the space. Because they see it as lucrative, right? Because it's not a liability fight; it's a quantum fight. So in a lawsuit, there's usually two issues: liability and quantum.
What's
Do I owe it?
quantum? What does that mean?
The first one, liability? Do I owe the money? Second one, how much do I owe?
Okay.
Right.
Yeah.
So in this particular field, the vast majority of the disputes, the liability is already established. It's relatively apparent because the termination is the crystallizing event. It's about quantum. Right. And that's what makes it fascinating because, as you say, I don't want market regulation either in employment. I think it discourages innovation to a certain extent. There are so many schemes. There are so many compensation schemes, bonuses, incentives, commissions, RSUs, equity, options. There's so many schemes, all of which can drive innovation or can reward an employee. When the company does well, they do well.
Absolutely.
I wouldn't want that to disappear, right? So I have thoughts about
That's
it.
interesting. I didn't even think about it from that perspective. I totally agree with you. One of the big problems we have in Canada is retaining talent. And part of the
Right.
reason we don't retain talent is because we have shitty capital markets. And
Yeah,
the
we see
reason
that all the time.
the reason that capital markets thing is really important is because of, if you don't have good capital markets, then you can't give people 1 billion stock options or whatever to invent the AI in University of Toronto. So they off to California instead. And you can see the major, some of the key players in AI over the last 10 years have all come from, not all, excuse me. A bunch of the key players have come from University of Toronto.
Right.
But because we have crappy capital markets and because we can't compensate people effectively with stocks and, as you said, RSU, which I'm still not sure I understand, but
Restricted stock units.
yeah, but you know what I mean? Like, your point is so well taken, again, from the standpoint of like Canada's weak productivity. How do we fix this?
So to all my regular listeners, I want to be clear. We haven't had like a pre-discussion. So you,
I
Rich,
hope I
you
didn't
just
screw up the conversation.
No, you just put
not
your
at all.
finger. You just
Not
put
at
your
all.
finger on one of the biggest cases in Ontario last year, which was Facebook v. Wigdor. And Wigdor was an AI innovator who sold his company to Facebook, became an employee of Facebook in exchange for a bunch of restricted stock units.
Okay.
And he got let go, and they had a fight about whether he would get his RSUs paid, and those RSUs were denied.
Really?
And the problem,
But he was given the RSUs.
Yeah. And the problem with that
But then you could just do that to anybody. You could just you could buy their company, hire them, give them $1 billion in stock option. As soon as they're your employee, you can just fire them.
But listen to this, Rich. That decision now stands for every Facebook employee in Canada, or in Ontario at least, who's under the same restricted stock unit plan. So all those employees who tipped the chart away from salary for more equity, watch out.
They're screwed,
Don't get
basically.
fired. If you get fired, there's a legal decision that says you're not getting your money. Right. So,
even if you quit as well, too, right? Because there's a vesting schedule for the RSUs.
Sarah, come on. If you
if you quit, you quit.
Any money, if you quit, you don't get any money.
Yeah,
right?
fine.
It's a general rule.
But your RSUs, like
Canada
if you're
that's actually no. Maybe Sarah does make a point, right? So
sorry, what was I didn't hear. Sorry,
so your RSUs vest over time.
Yes.
Yeah,
so let's say you're granted, I don't know, $200,000 in any given year as your RSUs. Now, those will vest over the next 5 or 10 years because it's a retention tool from the company. So they want to make sure that you stay with them. But let's say you're given that $200,000 and then you quit the next year. You've just forfeited a huge proportion of your compensation. And let's say your base salary is only $50,000 a year. The company is winning in that. Right, but you could say that the RSUs were already earned. So why are they forfeited?
But you could,
because they're in place of a salary.
Our solution to that
But
problem
that's the debate,
is
right?
often our solution to that problem is often to tell the client not to quit until the next round of RSUs
Yeah,
get paid.
obviously. But I knew that when I was like 21 years old, living working in London.
You'd be surprised, Rich. Not everyone knows
really?
that.
Oh
Not
man,
everyone knows
not
that.
everyone
Yeah.
knows.
Work and work and work. You at the factory, and then as soon as your stocks vest, you screw off to whatever job. It's funny that it's funny because I often think of Canada as being overly sympathetic to employees. But what you've just described is an extremely employer-friendly decision. Do I understand that correctly?
Correct.
Yeah.
Yeah.
This
it's
is
not,
the one
it doesn't.
situation.
Yeah.
I
It
would
doesn't.
say.
Well, but there are also employer-friendly jurisdictions. Like I don't want
Quebec, I'm sure.
I don't want to. Well, I don't want to. I don't want to pick
Commies,
a particular.
there are lots of
I don't
commies
want
here.
to pick. Yeah. I don't want to pick a particular province just on
No, I
the
was
off
just
chance
teasing.
that I
Sorry, I
end
have
up
no
getting
idea.
licensed to practice there. But
I have no idea. I was just teasing.
But I will say there are definitely jurisdictions or provinces in Ontario, or I was going to say there are provinces in Canada where it's very employer friendly. It's the other way around. It's actually really hard to set aside the contract. It's really hard to extract the common law notice. But what I will tell you is I don't see work flowing out of Ontario as a result.
Interesting.
Right?
Yeah, that was my question. I guess.
Yeah.
I mean, Sarah's point is right, which is like it's kind of it's on the Maslow's hierarchy of needs. It's far down the pyramid, I suppose. But cool, thank you. I mean, that was really interesting. I don't know. I'm still not quite sure what you do for a living, but
I could. The magician doesn't tell all his secrets, right?
No, but it was. I mean, it is interesting. Like it's wild. Again, how maybe we can just like go first. Full circle. It's wild to me that a judge would be like, what's the unemployment rate, vacancy rate, and the average salary for this particular job? I'm going to give this person X note money. Like that to me is nuts.
Well, but it's an entire practice of law.
Yeah. No,
they're about in Toronto. There are, I'd say there's somewhere between 300 or 400 really good practitioners
I gotcha.
like us, and it's fun because of course we see each other on all the files, right?
Cool.
And so one day you're on for the employer, the next day you're on for the employee.
Cool.
And some of what you're pointing out, the inconsistency, I guess, or the logical inconsistency, sometimes it becomes pretty apparent pretty fast.
Well, I'm also quite ignorant to this space, so it's unfair don't take my judgments too seriously.
I don't feel judged. What I actually think is important, right? People who aren't in this space, they bring an interesting perspective, right? Like your questions are great and insightful. And, some of your questions hit on some of the most topical, current, cases that we have going right now. So it's been actually really fun because
So I didn't embarrass myself too badly.
No, it's actually fun to bring someone. It's fun to bring someone else into our little world for a little while. And I also think by virtue of having a chance to talk to you and listen to you, like I understand more now some of the things that I've been listening to on your podcast. And so I really do appreciate that. I like you. It's the logical consistency is great, right? Because I think that there's a magic to that, or there's a power to that. And I think sometimes people forget that it doesn't have to be, it can make sense. It's allowed to make sense, right? And you're allowed to ask questions. And I think that that's great.
We're always learning. I think that's the key thing.
Yeah,
Man.
growth. We talk about that all the time.
The depth of my ignorance.
If we're not growing, we're not happy, right?
The depth of my ignorance is as I've just learned in the last hour, is quite.
Not at all. And you've got something to look forward to this spring. You got the Canadians going.
Oh man,
I think they're going to go deep. I think they're a fun team. I think they're a united team.
I don't know.
And you don't have to play Toronto. So although Josh Anderson is a Leaf killer. I don't know how many he scored against us, but I think it's like he scores all his goals against us. But, you guys have a great spring lined up. That concludes today's discussion. I want to thank Rich Diaz for joining us today. If you like this episode, please subscribe or leave a review if you have a case you'd like for us to discuss, or if you'd like to share your own story of workplace drama, and we love workplace drama.
Ooh.
Email us at watercooler. You'd be surprised what we get in the emails.
I'm down for that.
Email us at watercoolerjustice@gmail.com. Until the next time,